Your Excellency, Vice President of the Human Rights Council, Excellencies, distinguished delegates, fellow mandate holders, people of African descent. It is a pleasure to address the Human Rights Council in my capacity as chair of the UN Working Group of Experts on People of African Descent, and to report on the activities of the working group in 2024 and 2025, including the findings, conclusions, recommendations of our 2025 thematic report on reparatory justice, and the country visit to Colombia, conducted in May 2024. Since August last year, the working group has been engaged in numerous activities as outlined in the main report. In particular, the working group held its 35th and 36th sessions in New York, respectively from 2nd to 6th December 2024 and from 21st to 25th April 2025. These sessions offered the opportunity to bring a great number of people of African descent together to discuss the issue of reparatory justice, as well as to deepen our cooperation with experts of reparatory justice, civil society organizations, bar associations, and universities for a renewed partnership as we begin the second international decade for people of African descent, proclaimed in December 2025 by General Assembly. As funding has continuously been constrained in 2025, the working group has only been able to conduct one country visit to Suriname, and regrettably could not conduct the technical visits it is mandated to undertake for the second year in a row. Excellencies, distinguished participants, the thematic report on principles, provisos, and pathways to reparatory justice for people of African descent is a result of numerous consultation and written responses to the working group's call for submissions from states and civil society, and its 35th session. I thank the experts who provided very useful insights during the session, the participants, and those who submitted written reports. Reparatory justice for the enslavement, the trade in enslaved persons, including the transatlantic trade in enslaved Africans for centuries, subsequent colonization, and ensuing diverse forms of segregation is a matter of priority. Separated from their families, their communities, and their cultures, millions lost their liberty, their identity, their religion, as they were physically, sexually, and psychologically abused and subjected to degrading and dehumanizing treatment. They were taken from their families and communities that were torn apart, fearful, and scarred physically, materially, and psychologically. Today, people of African descent still face the legacies of these tragedies, as acknowledged by the Durban Declaration and Program of Action. Slavery, the slave trade, especially the transatlantic slave trade, are among the major sources and manifestations of racism, racial discrimination, xenophobia, and related intolerance, and that people of African descent were victims of these acts and continue to be victims of their consequences. The working group appreciates the initiatives taken at the international and regional levels for reparatory justice. These initiatives are a testament that different actors, including universities and churches, are more and more open to debate reparatory justice for Africans and people of African descent, and to take action in their respective contexts. Excellencies, distinguished participants, our report seeks to discuss the various dimensions that reparatory justice should cover: political, economic, social, and cultural. The working group found that although reparatory justice is necessary and should be inevitable, obstacles at the legal, political, and social and economic levels still persist and hinder the narrative for reparatory justice. From the legal point of view, proposals were put forward as a solution to overcome the legal argument of the application of the intertemporal law, which, according to some actors, may prevent any pursuit of reparations for past injustices, in particular the transatlantic slave trade. The working group therefore draws some conclusions. Enslavement, colonialism, and related abuses targeted Africans and their descendants as a group. Reparatory justice must be collective, comprehensive, and pursued with their full gender-sensitive participation, given the enduring impact of these legacies. Core common principles should be considered in the pursuit of reparatory justice, among others. Africans and people of African descent should be considered as the main victims who may put forward any claims for reparations. States that were involved in or benefited from enslavement, the trade in enslaved persons, including the transatlantic trade in enslaved Africans, and colonialism, and their successors should be considered as the main responsible actors. Reparatory justice should seek to eradicate the legacies and ongoing manifestations of these crimes and injustices. International recognition of enslavement and colonialism as crimes against humanity should be pursued. Reparatory justice should be comprehensive in its forms, namely compensation, rehabilitation, satisfaction, and guarantees of non-repetition, be acceptable to Africans and people of African descent, and comprise as a central tenet restitution, including the return and protection of ancestral lands given the spiritual, socio-cultural, and economic ties people of African descent and Africans have to these lands and the resources they contain. Reparatory justice should include monitoring and evaluation, as well as clear lines of accountability and responsibility. Reparatory justice should also include a system of incentives and sanctions. In terms of provisos, that there should be no statute of limitation on the pursuit of reparatory justice for the crimes of enslavement, the trade in enslaved persons, including the transatlantic trade in enslaved Africans, and colonialism. The cost of pursuing reparatory justice should be borne by the countries and their successors and the private entities that perpetrated enslavement and colonization or benefited from them. The working group emphasized that reparatory justice for Haiti should remain at the forefront of the pursuit of reparatory justice for and by people of African descent. In terms of pathways, the working group considers that the diverse history, geography, lived experience, and contexts of people of African descent require flexible, responsive, and evolving approaches and strategies in the pursuit of reparatory justice. Based on its findings and conclusions, the working group made several recommendations. Key among these are the following. Member states recognize the principle of reparations for enslavement and the trade in enslaved persons, including the transatlantic trade in enslaved Africans, as a norm of international law. Adopt a resolution in support of the delivery of reparatory justice in a comprehensive manner, notably through restitution, compensation, rehabilitation, satisfaction, and non-recurrence that considers each historical and country context and is grounded in international human rights law. Consider designating a United Nations mechanism to guide the process, and refrain from excluding prima facie compensation as a form of reparation. Hold a high-level meeting to examine the issues, concerns, and pathways related to reparatory justice for Africans and people of African descent, with a view to establishing the appropriate international body or mechanism to provide technical support to Africans and people of African descent in their claims, ensure accountability and oversight, and ultimately bring resolution and closure. Adopt research and evidence-based approaches to assess the harm caused to people of African descent by the legacies of the past, racism, and racial discrimination as a prerequisite for reparations. The United Nations should facilitate the formal recognition, acknowledgement, and apology owed to Haiti for the discrimination suffered through enslavement and colonization, compounded by the financial demands made upon its independence, and support the restitution of those payments as an integral element of reparatory justice for Haitians. Madam Vice President, Excellencies, distinguished participants, I now turn my attention to the visit to Colombia at the invitation of the government of Colombia. First, I wish to express the appreciation of the working group to the government of Colombia, including to its vice president, for their welcome and receptivity to the visit, as well as facilitating meetings and travel within Colombia. The working group met with the vice president, the vice minister of foreign affairs, senior officials from line ministries, as well as the Directorate of Human Rights and International Humanitarian Law, the National Administrative Department of Statistics, the Ombudsperson, the Supreme Court, the Special Jurisdiction for Peace, and local authorities. It visited Bogota, Tumaco, Cali, Northern Cauca, Buenaventura, and Quibdó. The working group also met with people of African descent, in particular victims and their families, human rights defenders, lawyers, academics, civil society organizations led by people of African descent, especially youth groups, community leaders, and women's groups, including from rural and remote areas in the Pacific coastal region. It further met with demobilized guerrillas of the FARC. The working group received written input preceding, during, and after the visit. It expresses its sincere appreciation to all contributors, including women, men, LGBTIQ+ persons, and young people of African descent, who shared their valuable testimonies, research, and their connection to their territories and lands. I would like to highlight the main findings of the visit. First, Colombia has in place the requisite legislation, legal and policy frameworks against racial discrimination. A number of laws and constitutional court decisions were passed in favor of people of African descent. Nevertheless, there still needs full implementation. The working group noted and documented a number of good practices that the government of Colombia has put in place, notably recent decrees advancing Law 70 of 1993 and the ethnic chapter of the 2016 peace agreement mark a historic step towards securing collective rights and improving conditions for people of African descent in Colombia, with transformative potential in areas like land, resources, and cultural preservation. The working group recognizes recent institutional advances in reparatory justice, including legal reforms, ethnic inclusion in rural development, and the creation of the National Intersectoral Commission for Historical Reparation. The working group raised the main following concerns. First, people of African descent experienced a lack of recognition at multiple levels, spanning from the absence of a positive narrative of their contributions to Colombian society, the absence of their history in textbooks, to the slow implementation of the right of self-governance as recognized in the provisions of the Constitution of 1991 and other relevant legal provisions, especially Law 70. Results of both the 2005 and 2018 censuses have been widely criticized for undercounting people of African descent. Second, development disparities between the capital and Afro-descendant regions like Buenaventura, Tumaco, and Quibdó are stark, with poor infrastructure, high poverty, and unmet basic needs, especially in Tumaco and Nariño. Corruption and illicit economies further deepen state neglect and insecurity in these marginalized areas. Third, despite having long-standing, legally recognized self-governance structures, communities lack full autonomy and legal protections, with poverty and poor infrastructure undermining local authority. Fourth, there was an evident general lack of representation of populations of African descent, including among areas such as housing projects in the territories and state-sponsored spaces for ethnic art and music. Fifth, significant barriers to access justice persist, including to free legal aid, as people of African descent mainly live in impoverished and remote areas. Land rights remain a major challenge. People of African descent lag behind in terms of access to employment and to the labor market. Finally, with regard to the right of education, the working group found insufficient measures to ensure full access to schools for all children of African descent. We make the following recommendations to address these issues. Operationalize Law 70 fully and recognize local leaders, especially community councils and authorities in their territories, and equip them and empower them with proper instruments of authority. Take corrective measures to ensure people of African descent are visible in official data sources. Confront all inequalities in access to education for people of African descent. Adopt concrete and urgent steps to promote access by people of African descent to employment. Madam Vice President, I wish to reiterate my appreciation to you and the Council for this opportunity to report to you and the working group's readiness to respond to any queries as we continue to build on 22 years of implementation of the mandate. Thank you.